Thank you, Kamla. It was a pleasure accepting this particular role. The High Court ruling in the SportTT case represents a significant application of fundamental corporate governance principles, particularly the fiduciary duties owed by directors and the limits of the business judgment rules. So I'm looking forward to hearing from Colin and the legal minds on the panel. While the monetary awards were modest, I think the ruling served as a significant deterrent by establishing personal liability for directors who fail to exercise proper oversight. This is a significant case, and it ensures that directors don't hide behind, well, the ministry told me so. They cannot rely on that anymore. Anyhow, we have Colin Kangaloo, we have Dr. Terrence Farrell, we have Yualande Christopher, and we have Chad Skinner representing Karen Perreira. Colin is SC was admitted to practice as an attorney at law in Trinidad and Tobago in October 1993. He joined Messrs. Fitzwilliam, Stone, Furnace, Smith, and Morgan as an associate in that year and became a partner in the year 2000. Colin was appointed senior counsel in May 2023. He heads the firm's litigation department and practices as an advocate attorney and handles diverse areas of civil law practice. Colin also served as a temporary judge at the High Court of Justice of Trinidad and Tobago from September 2007 to April 2008. He has served as a member of the disciplinary committee to hear complaints against fellow members of his profession from 2003 to 2007. And he's also a seasoned tutor at the Hugh Whitting Law School for 20 years in the areas of trial advocacy and for a year on the subject of civil practice and procedure. Apart from law, Colin is passionate about his dog. You'll find out how many he has. Liverpool Football Club, and horology, which I Googled, and is the study of time and watches and clocks, I suppose. I'm a big time guy too, but I don't study. Then we have Dr. Farrell. He holds a PhD in economics from the University of Toronto, an LLB from the University of London, and the LEC from the Hugh Whitting Law School. A former central bank deputy governor, he has worked for regional companies in IT, insurance, and media. He's also a certified mediator, a fellow of the Institute of Banking and Finance of Trinidad and Tobago, and a member of the CCGI, as well as serving as a director on several private companies. He has also served on government-appointed committees addressing various public policy issues and is a member of the National Advisory Committee on Constitutional Reform since 2024. He has published several scholarly articles in economics, has authored 3 books, Central Banking in Trinidad and Tobago, The Underachieving Society, Development Policy and Strategy in Trinidad and Tobago, and We Like It So, The Cultural Roots of Economic Underachievement in Trinidad and Tobago. And he's also co-edited The Caribbean Monetary Integration. Terry, it's good to have you here. I'm looking forward to your wisdom. And finally, we have Yualande Christopher. She's a civil and commercial law attorney from Jamaica with over 20 years of experience guiding clients through complex commercial disputes, litigation, and contentious estate matters. After honing her skills under the mentorship of distinguished jurist at Grant, Stewart, Phillips and Company, and with Charles E. Piper, King's Counsel, she founded Yualande Christopher and Associates in 2011. Her boutique practice specializes in civil and commercial litigation, corporate governance consultancy, commercial arbitration, corporate finance, tax, and intellectual property law, as well as residential real estate and banking law. She's an active member of the Bar Association of Jamaica's Civil Procedure Rules Subcommittee. and is currently entrusted with drafting Part 75 of the Civil Practice and Procedure Rules to streamline court intervention in domestic and international commercial arbitration. She contributes deeply to legal education and governance, serves as a tutor in civil practice and procedure at the Norman Manley Law School, chairs the Artificial Intelligence Subcommittee of the Private Sector Organization of Jamaica, the Private Sector Organization of Jamaica's Corporate Governance Committee, and acts as corporate secretary for several local companies. And then, well, we have Chad representing Karen and their firm, Inter-Caribbean Legal, which has offices in Barbados and Guyana. So, Chad, welcome. I don't have your bio, but I'm sure you're eminently qualified. So, Colin, without further ado, I'm going to hand it over to you to lead off the baton, and then we will bring the others in for the conversation. Over to you.
Sure. Thank you very much, Mr. Chairman. The judgment in SportTT was all about the duties of directors under Section 99 of the Companies Act. And given the factual scenario that we had to face, the subject of the company, which was the subject of the action, was a state enterprise. And the main finding arising out of the judgment, at least for me, the most important finding was that directors were not of state enterprises. Directors were not duty bound to follow the directive of the ministry or the shareholder in this case, who was the minister corporation sole. And even though, and I've seen a lot being written about the case and the judgment. And what surprises me is that in everything I've read, the writings were restricted to the duties of the directors under Section 99 in relation to a state enterprise. But what I'm going to say about the case and the law applies equally to non-state sector companies. So it's of the ruling made by Justice Rahim is really of general application to all companies incorporated under the Companies Act. So basically, in looking at a directive of a shareholder, or in this case, the ministry, the directors really have to consider the directives or the instructions from the shareholder alongside the concept of their fiduciary obligations and standard of care. And of course, as we all know, the standard of care and the fiduciary duty that directors owe to a company are set out at Section 99 of the Companies Act. And usually, and you will hear this phrase very often, when a director makes decisions and are carrying out their duties under the Companies Act, you will hear that they have a duty to act in the best interest of the company, and to act with a certain amount of due diligence and skill and of a certain standard of behavior. And sometimes, that is such a nebulous concept because, people ask, well, what is it that we have to do to act in the best interests of the company? What factors do we have to take into consideration? And I think in looking at that Section 99 and the duty that is set out there, I think really if a director makes an informed and independent decision on issues that they're confronted with at the board level, that could go a long way in acting in the best interests of the company. And in practical terms, I tried to think of examples for this morning of what directors can do or should do to be acting in the best interests of the company and to act with a certain standard of due diligence and skill. So if we had to break it down, and my list is not exhaustive, and you know, it could be very fact specific as well, depending on the nature of the company and the business of the company. But certainly at minimum, these are some of the duties of directors that I see would go a long way in helping them to act in accordance with Section 99. Firstly, I think they have to attend meetings. And basically, if they can't attend directors' meetings, they must have a good reason for not attending directors' meetings. The second thing is the minutes from the meetings. You have to acquaint yourselves as directors with the minutes of the meetings, and you have to know the minutes of a meeting intimately. The third thing is you have to understand the business of your company, and not only understand the business of the company, but you also have to stay informed about the developments in the business of that company. The fourth thing is you have to review. It is your duty to review and understand financial information and statements that come to you as a director of a company. The fifth thing is that you are mandated as a director of a company to safeguard its assets. You have to take reasonable steps and be aware of reasonable steps to prevent and detect fraud that could happen within the company and amongst the staff of the company and outsiders. The sixth thing, you have to maintain confidentiality. What you see at a board level and what you are exposed to, those are confidential matters and should be kept confidential. The next thing, you need to avoid conflicts of interest as a director, especially in relation to contracts. You can't benefit or should not benefit off contracts in relation to the company unless, of course, there is full disclosure. And the last thing that I considered, which may seem a very unimportant thing, but I think actually it is one of the most important things. It is your duty as a director to ask questions, because you can't just sit back, remain silent, and not ask questions. And so those are some practical aspects of acting in the best interests of the company and of acting to a certain standard. Under the old law, the law we had before we adopted the Canadian position on our Companies Act, under the old English law, if there were breaches of fiduciary duties and you were negligent as a director, you could be forgiven. You could be forgiven by the shareholders. They could simply have ratified what you did that was wrong and accepted what you did. That is not the case under the new law that we have under our Companies Act. Because if you look at 99.6, and this is important because, 99.6 says that a director cannot be relieved from liability for a breach of the act or any regulation on the act. And so therefore, a breach of fiduciary duty cannot really be ratified by a shareholder. But I'm going to talk about something else which can protect a director later on, and they will be protected depending on the circumstances if something is in place. But without that something, there can be no ratification of your breach of fiduciary duty. And that, because there can be no ratification of the breach of fiduciary duty under Section 99, this also calls into question, and I'm just going to touch on it just to think about it, the indemnities given by a company to directors. Because under Section, I think it's 101, for the indemnity to hold, basically the director has to show that they acted honestly and or in good faith in the best interest of the company. And that is the same test that is present under Section 99, which is the fiduciary duty. And so therefore, if you run afoul of Section 99, obviously you won't be able to get the benefit of an indemnity redirectors. But there are also inbuilt protection provisions for directors under the Companies Act. So, for instance, if directors rely in good faith on financial statements of a company presented by an officer or a report of an attorney at law, accountant, engineer, appraiser, or other person, the fact of the matter is, if you honestly and in good faith rely on those reports and you make a decision on those reports, you can be protected under Section 100, subsection 4. And if you miss a meeting, for example, one of the things I said was you should attend meetings, but if you miss a meeting and you get the minutes afterwards, and you see in the minutes that there is a decision that you disagree with, you have a duty under Section 100, subsection 3, to write within 21 days of receiving the minutes or being aware of the decision to say that you do not agree with the decision. And if you don't do that, you lose the protection because you would have been taken to agree to the decision. And that also was an issue in the SportTT matter with respect to a party to the litigation. But directors can be protected generally if there is a unanimous shareholders agreement. And that is under Section 137 of the Act. And basically, with a unanimous shareholders agreement, what happens is that the power of directors to make decisions, either in whole or in part, in the management and running of the company can be transferred to all the shareholders. If that happens, then the shareholders fall into the shoes of the directors. And the fiduciary duties under Section 99 would apply to them and not the directors. And so the directors are really given a free pass. The difficulty that I could arguably see in having a unanimous shareholders agreement in relation to a state enterprise is that I think state enterprises, the identity of a state enterprise is being challenged more and more in the courts. And the challenges are usually in relation to whether there should be a lifting of the veil to see the company and the shareholder, who is the government, as the same, so that the liabilities of the company can be the liabilities of the government. And to move in a way to have a USA in relation to a state enterprise could be one of the factors that a court will take into account in deciding whether or not to lift the veil and have separate and to have the same liability on the company and the shareholder. And state enterprises were brought about because of the provisions of the Central Tenders Board Act. It was cumbersome. Projects took long to having to go through that. So what the state did was incorporate these special purpose companies under the Companies Act to make it easier and to help with the administration of projects, etc. But I think one of the advantages that the state had and they still have with respect to state enterprises, the fact that there is a separate legal entity, and so therefore liability falls on the company and not the shareholder. But I do think it brings into question, if you have a USA, does it make it easier for a court to say, well, I'm ready to lift the veil and treat shareholder and state enterprise as one? I mean, that's basically what I want to say about the principles of the case. And the last thing I would mention is that there are other types of corporations in Trinidad. They're the ones that are incorporated under the Companies Act. But remember, we have the corporations that are also established by statute. So you have HDC, for instance, that is established by statute. You have WASA, that is established by statute. You have TNTech, that is established by statute. And what Section 99, my view is Section 99 of the Companies Act doesn't apply to the directors or the commissioners of these entities, because within the statute there's usually a provision which says that the directors or commissioners are bound to follow the directive of the line minister. And so if they are bound statutorily to do that, I don't think we can challenge them on that later on. Although someone from Bermuda got in contact with me, and he's doing a case in Bermuda where they are challenging obligations of the directors on a state enterprise, on a statutory corporation, because they are arguing that the instruction was not lawful. And so I asked him to keep me in contact to let me know what's happening with that case. So, I mean, that's it from me. It's an interesting case. I'm sure generating a lot of discussion, and we'll see where we go from here.
Thank you very much, Colin. Very good. So I'm going to ask Terry to jump in and opine, give us his perspective, and then we move on to Yualande.
Okay, well, I think Nigel, you probably would realize that my perspective is going to be a little bit different.
Of course.
For my sins, I was the chairman of the State Enterprise Review Committee of 2016. So I know a little bit about state enterprises. First of all, as far as the judgment is concerned, the judgment is not a landmark judgment. Some people have been calling it that. In fact, a couple of attorneys have called it that. It is not a landmark judgment. It does not produce any novel issues in respect of the law. What Rahim does, Justice Rahim does, that he applies the law in the context of the Companies Act. So in the context of private limited liability companies, he applies that to the particular case in front of him. The second thing is that it is not novel. This SportTT case is not novel. Over the course of the last several years, we have had several cases, some of which have reached the Privy Council. For example, the ETEC matter. Now, the ETEC matter reached the Privy Council, not on the substantive issue, but it reached the Privy Council because the defendants charged limitation. They said that the thing had the previous statute of limitations, and they went up to the Privy Council on that basis. But what has happened in Trinidad over the course of the last 15 years is that with changes in government, what has happened is that incoming directors, incoming boards have charged the former boards with breaches of fiduciary duty. And this is what we've seen with the SportTT thing. We've seen with ETEC. In the case of there's another UTT, which also involved Ken Julian. So it is not novel. What is different about this one is that the people get charged and they got fined, and that is what kind of got people's attention. One of the things that I noticed about the judgment, of course, only a summary that Justice Rahim has done so far, is that the history of our state enterprises, I don't think he quite captures it quite correctly, right? As Colin points out, we have two or maybe three different kinds of state entities. There are statutory corporations. They are set up by statute. So HDC and NAMDEF-Co, Agricultural Development Bank, a whole bunch of them and so on. Now, what happened is that there were private state enterprises incorporated in Trinidad before the 1990s. In fact, the first one that we identified was a company, strangely enough, called Palo Seco Agricultural Enterprises, which took over a lot of the lands that were given by the former oil companies operating in South Trinidad. That was the first limited liability company that was, in fact, a state enterprise. We had companies like Trintop, Trintopec, Petrotrin. They were all limited liability companies. But what happened is that in the 1990s, the government, and Colin is right, because of the provisions of the Central Tenders Board Act, and the government wanted to get around that, they decided to use the device of incorporating private limited liability companies. And the point is that these companies are incorporated not only for doing things in the sort of a commercial thing, like First Citizens Bank and National Gas Company and so on, but all the other kinds of things, development enterprises. We classify them as development enterprises, social enterprises, special purpose companies, education facilities, doing project management. All of these were incorporated under the Companies Act. And they generate no revenue. They're entirely supported by the government. And so therefore, what has happened is that you now have these directors appointed to these entities like SportTT. SportTT has no revenue. It is entirely based on subventions from the government, as are in fact most of them. And you put directors in place, and now a situation like LifeSport arises where the ministry tells the directors, this is what we want to do. The directors go ahead and do it, and now they find themselves stuck with these penalties. Now, when you look at Justice Rahim's judgment, the thing about it is that but let me just say one other thing. This thing called the corporation sole that we have in Trinidad, corporation sole is the shareholder. The Corporation Sole Act dates back to 1973. In other words, it antedates the Companies Act. And all that the Corporation Sole Act does is that it vests state property in this thing called the Minister of Finance Corporation Sole. And it's a corporation sole simply because it's not vested in the individual, but it is invested in whoever happens to occupy the office of finance, or Minister of Finance at the particular point in time. The Corporation Sole Act says absolutely nothing about anything other than the fact that assets and property of the state are vested in the Minister of Finance. So he's the shareholder, right? But it says nothing. There's no articulation between the Corporation Sole Act and the Companies Act, or any other thing for that matter, that can give you some guidance as to how state enterprises are supposed to operate. But the point is that when you come now to the State Enterprises Monitoring Manual, which was published in 2011, what you see there is that you see a structure of government which is completely different from the structure that is set up for private companies under the Companies Act. Totally different. You have a cabinet on top of there. You have something called a line minister. You have something called the corporation sole. You have the board. You have lines drawn in that chart in the State Enterprise Performance Manual, hard lines between the line minister and the board, and hard lines between the line minister and the CEO of these enterprises. The point I'm making here is that state enterprise governance is a completely different animal from the governance of private companies. Now, the problem is that they are incorporated under the Companies Act. And so therefore, when a situation as in LifeSport arises, the judge is looking at the thing, and the judge therefore says, well, what am I going to apply? What am I going to do? And what he does is that he applies the law that is in front of him. They are companies incorporated under the Companies Act, and that is what he applies. Now, I did a slide, and I think that was the only slide that Kamala wanted me to show. And I don't know, Kamala, if you want me to bring up that slide. Can you share it for me, or you want me to share it?
So you can share it. You have.
Let me see if I can do it. Right. So here's what Justice Rahim says. He says the essential question is whether directors of private limited liability companies, SportTT, were duty-bound to follow the directive of the state if it is found that there was such a directive or directives through the instructions of the line minister or the permanent secretary when making decisions, or were they duty-bound by virtue of their duty under the Companies Act and the common law to act independently. And I've highlighted all these things that I think we need to focus on, so as to determine what is in the best interest of the company, even if they had been directed or instructed by the state. The next question is then whether they so acted. Oftentimes, he says, and this is a very controversial statement, I think, in the judgment, oftentimes the goals of the state enterprise and the instruction align with what is in the best interest of the company, but the problem develops when they do not. I don't know what is the empirical basis for Graham saying that, but it begs some questions. So I'm saying we can immediately see the contradictions and the difficulties here. What does it mean to describe these entities as private? They are not private. They are state-owned entities. They're not a private company. But they're incorporated under the Companies Act as private limited liability companies. So that's how he treats them. What does it mean to give the board of a private limited liability company a directive? How could that possibly arise? That could never arise in the context of a private company. unless you have things like shadow directors and so on and so forth, which we know from company law. But a directive, how does that come about? In what sense, if any, is the liability of an SOV limited? The whole question of who bears liability? The Companies Act says that, yeah, the directors could be personally liable. But in the case of a state enterprise, what does that mean? What does that mean if you are the director of NGC, which is a company with assets of billions of dollars? What is your position? What is the meaning and role of a line minister or permanent secretary in respect of a limited liability company whose sole shareholder is the Minister of Finance Corporation sole? The line minister has no legal authority to give anybody any instructions about anything. What does it mean in that context? I'm asking myself, or the permanent secretary, how does this arrive? Now, it is in the State Enterprise Performance Monitoring Manual. You'll see the chart there. You will see the lines drawn there. You will see all of that written out in that manual. But the point is that it is just simply a document. It's a manual, right? And if somebody becomes on the board of a state enterprise now, is then found themselves in what I consider to be a real total dilemma. What does it mean for the board of directors of a state-owned enterprise to act independently? What does that mean? I have no clue what that could possibly mean for somebody who is running, which you are on the board of a state-owned enterprise, that you can act independently. So that means to say that you are the board and you could decide to make up government policy. Government owns the thing. Government wants the thing to do a certain kind of thing. It wants to run a particular kind of project. And you as the board of the company will say, no, we're not going to do that. That we are going to be doing something else. That we don't like what you're telling us to do. And therefore we're going to do something else. How could that possibly arise? Now, what does it mean for the interest of an SOE to diverge from the interest of the government? This is the question. This is the dilemma that the directors of SportTT, and let me put it this way, every single director of a state enterprise incorporated in this fashion now find themselves in. The ones who are statutory corporations have no difficulty. Their legislation says that they are subject to a ministerial directive. They have no shares in those companies. So they take orders, and that is understood. But in the case of these enterprises, which are incorporated under the Companies Act, where there is nothing else, they are going to find themselves in this situation, right? So the question is, what do you do? As a State Enterprise Review Committee, we had suggested to the government, this is back in 2016, we pointed out the problems of governance in respect of these state enterprises, that governance is flawed. It is not going to work. And I think SportTT has now demonstrated clearly to directors that they are going to find themselves and can find themselves in trouble. I mean, Rahim was very lenient, as he said in the judgment. He said, I'm only going to fine you all $40,000, right? But it could be more. What is your personal liability in that situation? So what we recommended to the government back in 2016, which of course they have ignored totally. And the reason why they ignore these things is because state enterprises are there for political patronage. That is what they're there for. They take these enterprises when a new government comes in and they farm them out among all of the different kinds of ministries that they have, and ministers then get to decide who is a director and who is this and who is that, and they can then get to decide who to employ, and they can call up the CEO on the phone and tell them that they want to employ this one and want to employ that one, and that is how the system works. Now, the system does not work that way in proper countries, right? And what we said to the government is, look at the New Zealand model, or if you like, look at the Norwegian model, two small countries. And what they have done, and we've recommended this to the government, is that on top of the Companies Act, you have a separate piece of legislation, a State-Owned Enterprises Act, that creates a regime for state-owned enterprises. So if you want to incorporate them first as a company under the Companies Act, perfectly fine. Because one of the reasons why that is helpful is that because the whole governance arrangements and all of the things that we know in respect of company law in terms of guidance of directors will then apply. But then on top of that, you layer on top of that the particular regime that you want to have for state-owned enterprises. A state-owned enterprise must have, in the New Zealand case, in the case of the Norwegian case, what they call a statement of corporate intent. You have to say what it is the enterprise is about, what is its purpose, how it is going to achieve that. And they're supposed to renew that all the time with the parliament. Every new minister comes in, you go and you say what your statement of corporate intent is. You have key performance indicators, and you have a regime that directors therefore know what they're operating under. Our directors are terribly exposed, as we are seeing in the SportTT situation. And it begs my question, and I will end here. I have no clue, given the Integrity in Public Life Act, given the fact that you now become a politically exposed person, given the fact that you are subject to unlawful directions from a minister. Ministers give people unlawful. Look what's happening with the CPEP situation that we are facing now, where people are saying that, yes, well, the cabinet tell them to renew the contracts, and people are saying, well, no, the cabinet never tell them to renew the contracts, and so on. Unlawful directions you can get from a minister, because the ministers are not going to put anything in writing. Anything that you want to do that is going to be marginally illegal, they will never put it in writing, but they will expect the state enterprise to carry it out. So in those circumstances, I ask myself, why would anybody want to become a director of a state enterprise? So, Mr. Moderator, let me end at that point. Thanks.
Thank you very much, Terry. And I assume when you talk about state-owned enterprises, you mean 100% owned, wholly owned state enterprises. But we will get to that after, because we have where I was at NFM, and we have First Citizens, which are owned by the public of Trinidad and Tobago as well. So let's go to Yualande and hear from her, and then we will. I'm looking forward to this conversation. Yualande.
Thank you, Chairman, and good morning, everyone. It
Good
is
morning.
indeed a pleasure to be part of this timely and critical discussion that we're having, particularly at a time when the region has become more assertive in the enforcement of board accountability. So the SportTT judgment for me was, in fact, a reminder, not just to Trinidad and Tobago, but to the entire region, that public boards are not mere extensions of ministerial will. They are, in fact, they comprise independent fiduciaries who owe duties of loyalty and care to the state entity which they operate. And when I reflect on that judgment, Justice Rahim's judgment, what I see is that it isn't simply that he held the directors liable, but he held them liable for doing too little. In his opinion, their silence, the inertia, and deference were not neutral acts. They were breaches. And to my mind, no director asked the difficult questions, certainly not enough, or interrogated flawed proposals. And so it didn't shield them from liability. And when I consider Jamaica, which is my home country, there are several examples and instances in which that whole tension sometimes plays out between the weight of ministerial expectations and the struggle that directors face in putting duty above those expectations. I'll just name two examples by stating the controversial incident by the state-owned National Energy Solutions Limited that fell under the portfolio of our Ministry of Science, Energy and Technology. And that had a massive fallout, resignations and allegations made. And another one I can think of readily is the Petrojam case. That was the Petroleum Corporation of Jamaica Limited, where we saw very, very serious corporate governance failures, allegations of nepotism, breaches of procurement, concerns that the board simply turned a blind eye to blatant red flags. we saw charges being laid in that and dismissed, but more than anything else, the public confidence that was in state-owned enterprises took a massive dip, reputational harm to professional reputational harm to board members and, members of those entities. But our last speaker raised a very important issue when he mentioned that the Companies Act did have its own regulations, but he would recommend that there be additional recommendations in place to specify what exactly state-owned boards are supposed to be loyal to. Is it that they are to promote the fiduciary duties or promote the agenda of the ministry that they fall under? In the case of Jamaica, we are bound by the Companies Act sections, I think 176 and 77, which speak to the fiduciary duties that boards owe. But on top of that, we have the Public Bodies Management and Accountability Act and the Corporate Governance Framework for Public Bodies. And those two pieces of regulations speak to how boards of state-owned enterprises are to act in giving their own policies and objectives, which would set them apart from private enterprises. And, when you think of that, when you think of the fallout and the tensions that happen between board members and ministry, you wonder why that happens. In my experience, it's a matter of an absence of training in many instances. Board members do not know that they have a fiduciary duty. They believe that they are there to further the agenda of the respective ministry. They don't know about the corporate governance policies that underpin these fiduciary duties. Policies are documents which sit on shelves and gather dust. They're not integrated into the culture of the organizations. They engage in self-dealing, breach procurement guidelines, and all kinds of things. But I would close by saying that the way forward involves training, the laws, as the last speaker mentioned, regimes, policies that are put in place, regulations, and documenting dissent. If you see something happening that does not agree with your duty, your fiduciary duties, you have a duty to speak. And not just to speak, but to ensure that it forms part of the minutes. Verbal ministerial endorsement of a contract will not assist when, if there is a fallout. There are several others, but I will leave it there, Chairman, and turn the virtual lectern back over to you.
Thank you, Yolanda. And now we turn to Chad Skinner for his comments, and then we will get into the discussion, because I have a few questions myself. Chad?
Hi, good afternoon. Thank you, Chair.
Good afternoon.
Yes. To us, the judgment really highlighted the importance of, or the significance of, separate legal personality. There is a shareholder, and there's also directors, and the two are not the same. And that is something that may be forgotten in public enterprises, public state-owned enterprises, and also in some instances, private companies, which are held primarily by a majority shareholder. And even though practically, which is important to say, that in some state-owned enterprises, directors may be of the view, okay, well, I need to listen to what the minister states. Because perhaps I may have been appointed by him or her, or perhaps this is in the best interest of the company, not the company, the public. But the duty of the director isn't necessarily to the public, it is to the company. And to me, this case emphasized that. More importantly as well, is that the idea that due diligence and acting with due care and attention is not just a formality, but instead it's a backbone of responsible directorship. And that is especially so in public companies as well. And in this case, there were several red flags, and ignoring the red flags or not paying due attention to them did amount to a degree of negligence and a breach of statutory duties, as the court have found. Another important thing which this case also emphasized, at least in my view, is that the inaction of a director does not amount to protection. So if it is that you're on a board, whether that be a private board or a board of a state-owned enterprise, you must dissent where you do not agree. No. The Barbados Companies Act is actually somewhat similar to Trinidad. For example, whereas Trinidad has Section 99 stating the duties of directors, in Barbados we have Section 95, which states basically the same duties. And then after Section 95, we have Section 96, which talks about dissent. Dissent can be during the meeting itself, dissent verbally, or it can be done in writing to the corporate secretary, or even after the meeting, immediately after the meeting, a director can send his dissent to the corporate secretary, and that can be recorded. And that is something very important because in some instances, based on who may be in the room or on a call, a director may not feel comfortable at that time to state that he does not agree. Also, what happens, the question then is also what happens if a director is not there? This was stated earlier, but essentially, and a difference between Trinidad and Barbados is that in Trinidad, you have 21 days to state your dissent if you're not present. In Barbados, you have 7 days after you become aware of the content of the meeting to state whether or not you dissent. And the reason I would like to just emphasize the importance of dissenting again is because in this case, the director who chose not to comment or opine at all, he was still held liable. He was still faced with a nominal fee, as the court decided, it was $40,000. So I just would like to emphasize the importance of dissenting as well. Now, one other thing which I would like to touch on is solutions. Basically, what could be done? It is important fundamentally that directors are trained. Training of directors is important because, say for example, you are sitting on board because you have expertise in engineering or expertise in information technology. You're an expert, you're very knowledgeable in your own field. However, the responsibility of being on a board is different from your area of expertise. Therefore, training is required. And you must have an understanding of what is required of you. For example, earlier, it was mentioned about reading the minutes of the meetings, and staying abreast of the policies and the actual business of the company. All of those things are important. And sometimes from time to time, even if you've served on boards, it's very important to refresh your memory as to what is important. And regulations change from time to time. Currently in Barbados, we have regulations on corporate governance. And an important aspect of that is independent directors. And independent directors are critical to ensure that the business of the company runs smoothly, is efficient, and is managed correctly. And in state-owned enterprises, independent directors may be challenging. It may be a challenge to have independent directors, but the structure of the company or of the state-owned enterprise could be adjusted to account for some of these things. For example, let's say that in this case, there wasn't a proper tender process because the minister had said, hey, let's go with this person, and everyone just said yes. But structurally, from corporate governance perspective, if things were done accordingly and in place, it should have had a committee that would have reviewed the tenders and whatnot, and that would have absorbed some of the liability. Structuring boards and subcommittees of board is critical, not just because it may sound nice to do, but practically it helps absorb the liability of directors. And that is critical, especially given the fact now that if you fail to uphold your duty, director's duty, acting honesty and good faith and diligence and skill and care, then at the end of the day, you can be held liable. And just one more point on that note as well, why this is even more critical, because practically as well, with changing governments, the needs of what may be deemed in public interest may change. So at one point, when you're acting in public interest instead of acting in interest of the company, you told yourself, hey, this is great. But then a government may change, and the new government will view your actions not in the interest of the public. So what you should really be doing is acting in the interest of the company, the best interest of the company, and also having those structures in place and making sure that there's adequate education for directors and the adequate committees to suit your business needs, and also the complexity of the organization itself. Because what may work for one organization, that may, when you have 10 people, isn't going to work for an organization for 100. What may work for an organization that has a portfolio of, let's say, $100,000 may not work for an organization with a portfolio of millions. Those are things to take into account. Yes.
Thank you very much, Chad. So let's bring our panelists on screen, and let me ask my first question, and anybody can answer, but it's directed at Terry's point about you're a state enterprise. So from my little research, what seems to have come through is that the directors follow the directive without question. So my thing is, you are there to deliver a certain result. It is suggested that this company can deliver on that result. As a director, if I had read the document, understood the document, and been competent, my questions would have been, bam, 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 bam. I have my concerns. I understand what you're trying to do. I don't think these people are capable of doing it. And this price seems way out of whack. In other words, and I think somewhere Colin said it, this was a case of documents. The documentation wasn't there. Nobody questioned it. In fact, it came across as if nobody even read. So for me, as a director, you got these documents. This is what I am seeing, and you did not push back. You did not question, and therefore, for me, this is the source of the issue. So whether you have an overarching piece of legislation over the Companies Act, you are still required to question, to advise, to give your considered opinion. And that's the only way you can protect yourself. That's how I see it. So anybody can feel free to jump in.
But I think the last thing that you said there, Nigel, is correct. that whatever the regime we're talking about, the directors have a responsibility to question. In the particular SportTT case, as reading the summary of the judgment and so on, there were a couple of directors who questioned the thing. You see, what had happened is that the ministry, it was a sole select, right? The ministry told them, hire this fellow. And the ministry told them, this is the amount, right? And a couple of directors did question it. One of them went through from reading Justice Ryan Judgement, and Ronnie went through the thing, and he had his doubts, and he raised questions, and he eventually agreed. One of them said, I wasn't there, and I didn't think. But when she came back to the following meeting, she then ratified the decision, and she gets caught. So it's but you see, what I am trying, the point I'm trying to make is that state enterprises are not the same thing as any other kind of entity. It is not the same. They are carrying out public policy. So if I am SportTT, or if I am InvestTT, or if I am Richard Young is here, if I am former chairman of TTIFC, the government has a policy about what it wants to do. And the company is the vehicle by which it carries out that particular policy. Right? Now, in those circumstances, I am saying that a director or the board of directors does not have the same kind of scope and latitude of a director of a private company, of a First Citizens Bank or Republic Bank or any private company. They do not. They can't make up public policy. That is the prerogative of the government to do. And the government says, you are the vehicle that I want to use to do that. Now, we have had instances in Trinidad where, some of you remember, some of you may be too young to remember, where we had the Tourism and Industrial Development Company of Trinidad and Tobago paving roads in Trinidad before an election. The tourism company paving roads in Trinidad. Now, that is not clearly not part of the responsibility of the tourism, but the government of the day said, I want somebody, and you have money, and you go ahead and you do it, and they did it. Now, in those circumstances, you might very well ask the question, well, what is the role of the board of directors? Can they push back? We have had other egregious instances. For example, National Gas Company, a critical state enterprise within the scheme of things. It is bigger than any other state enterprise in the country, bigger than TPHL. National Gas Company is supposed to be a critical company in respect of our upstream development. Under previous government, what happened? The government took dividends out of NGC, took special dividends out of NGC in order to fund the budget. In those circumstances, what is the responsibility of the board in those circumstances? The board can say to the government, to the Minister of Finance, listen, if I pay you this special dividend, you are going to deplete my capital, and I will not have sufficient resources to do the upstream development work and so on. And the government will say, I am the government, you are my enterprise, I want that money to come into my budget, and that's what happens.
Let's hear from Colin, because for me, the documentation is important, and you just can't say it; you have to document it. Colin.
Well, I just want to go back to something Dr. Farrell said when he said it was not a landmark judgment. And, I felt a little down hearing him say that, but okay, I'll get over it. I'll get over it. But actually, he's sort of right in saying that, because in 2003, there was a case called Orokun, and it's a judgment of Mr. Justice Smith, as he then was. And basically, there were things that he said in that judgment about a state enterprise being incorporated under the Companies Act. And one of the things he said is that if Parliament had intended the state to retain direct control, it should have, over a company incorporated under the Companies Act, it should have enacted legislation to do so they could control. And that's the point. The point is, and this is where I disagree slightly with Dr. Farrell. If you go into an entity that is controlled, that is formed under the Companies Act, I mean, your duties are pursuant to the Act. And, and whether you like it or not, the fact of the matter is, if a minister, parliamentary secretary, or anyone attempts, anyone can give you directives, there's nothing wrong. I don't see anything wrong with a ministry or a parliamentary secretary giving directives. I actually don't see that as wrong. I think the onus then falls on the directors to consider the directive and to say, well, okay, I hear this directive, I understand what they're trying to do, but is this going to cause harm to the company? And that's how the directors have to think. And they only have to think like that because the vehicle that is being used to incorporate the company is the Companies Act. So I do think once you have attendant liabilities and duties under the Companies Act, you just can't follow directives from a shareholder or a ministry or a parliamentary secretary. And that's how I see it. In terms of what I meant about it's a document case is that, the case came after people had left and stuff. And my thing about it was, well, look, you have all these documents here. You have the RFPs, you have the joint sole select document, etc. And all you have to do is read it and see if the proper questions were asked about the documents. That's what I meant. And everything was there before the court. And Justice Rahim looked at the documents and came to a view on everything else and about the documents and what was done and the decision that was made. And we were fortunate to have the documents in the case. And just a minor thing. I know some of you all will think that this is really semantics on my part, but I've heard it before. And, people say that the directors were fined. They actually were not fined. I mean, it was a civil case, and we don't talk about fines in a civil case. We really talk about damages. And that's what the judge did. What the judge did was, after considering everything, he made this statement, and whether I agree with it or not is irrelevant, but he did make the statement that he can't quantify the damages, but he says there is loss. And so what he did was he awarded nominal damages, and that's the 40,000 that people are seeing, but it's not a fine. A fine imputes something else, and so we really, I'd be very happy if we talk about damages as opposed to fines.
Yeah.
I have to agree with Colin on that, though.
Yeah, go ahead, Yolanda.
Right. Colin, I agree with you that you can't simply check out of your fiduciary duties because you operate a state entity and you know an agenda that aligns with the ministry. You can't. You really can't. But Dr. Farrell does have a point that if you want to make, I think the issue here is clarity. Boards must understand that they have a fiduciary duty irrespective of the ministry's agenda, and that clarity comes from policies that are made clear specifically for these boards.
I'm not saying that. I come back to the New Zealand and Norwegian examples and so on, right? First of all, on the question of instructions, Colin, right? The line minister can't instruct them. He can't instruct them because the line minister has no nexus to the company. The only legal nexus to the company is the Minister of Finance Corporation sole. So it's one of the reasons why in New Zealand, when the enterprise is created, they have two sets of shares, one for the Minister of Finance and one for the responsible minister, because they understand that. The airline people, the Minister of Transport deals with airlines. The Minister of this deals with agriculture. So he gets the share to deal with the agriculture enterprise. And he can then do the instruction. You see what I mean? But the Minister of Sport, has no legal nexus to the enterprise, the SportTT. That nexus is the Minister of Finance Corporation. So he can't instruct them. You could in fact tell the Minister of Sport, I am not obeying your instructions. In fact, Colin, under the Uff Commission of Inquiry, Professor Uff in that Commission of Inquiry stated when he was dealing with Udicot, he said, I have looked at this thing and it is clear to me that a minister cannot give instructions to the enterprise. You don't have to follow it. That's what he said. I mean, it wasn't a court case, but that came out of the inquiry. So to solve that problem, I'm saying we have the precedents. We have the precedents. You have to have the two sets of regulations, the Companies Act, and then you have an SOE Act on top of that, that creates a regime for these entities. A company cannot pursue a policy that is different from the government. It can't.
But Terry, I have a question for you here. Policy is one thing.
Yes.
How you execute that policy is another.
Right.
And for me, as a
Yes.
professional, as a
Yes.
director, I have an obligation
That
to
is
push
correct.
back on the minister and I say, you want this done? This is the way we believe it should be done.
And you are absolutely right. And again, the New Zealand and the Norwegian paradigms tell you that. They say that the minister has no operational responsibility outside of the annual general meeting. He doesn't get involved. He tells you what you clearly you say what your corporate intent is. So this is where Yolanda's point of clarity. You are clear about what you are supposed to do. Now a project will arise. Your job as the directors would be to say, I want to see 3 different bidders for this thing. I go through the process. I carry out my fiduciary duties. And Yolanda's point in Jamaica, under the Public Bodies and Accountability Act, it tells you that you're supposed to do these things. So we're not saying you're not doing those things, you know, but you're doing that within the confines of public policy. You can't go outside.
And I accept that. I accept that.
Good.
Yes, definitely. Definitely. Do we have any? We have 2 questions that I want to highlight. Richard said he would love to hear how our procurement regulations for state-owned enterprises may change directors' responsibilities. And then Lara Quentrell Thomas said, do we anticipate that this judgment is going to result in a reduction in the number of persons willing to serve on state boards? The IPLE is already, the Integrity in Public Life Act is already a deterrent to some. Chad, what do you think? Unmute yourself.
I think that, well, the judgment does clearly show that directors of state-owned enterprises can be held liable for their actions in breach of the duty. And to some persons, that may be a deterrent from acting as a director of a state-owned enterprise. However, I do not think that it would, there are 2 things. One, I do not think that it would ultimately cause a whole set of persons being unwilling to act as directors. I do not think that would cause a lack of directors being available to serve. Secondly, the thing that may come of this is that as a result of this judgment and possibly other future judgments, is that there may be a change in policy or legislation which or even guidelines being issued that may help tighten up the deficiencies in how state-owned enterprises are run, so that it may actually encourage persons to even want to become directors of these entities because they bring more structure, and therefore there may be a sense of indemnity which may be offered to directors, future directors.
Either that or some training so that they understand what they're getting involved in.
Yes, training is incredibly important.
Yeah. Yualande, do you have anything? Colin, I see you unmuted. Go ahead, Colin.
Mr. Chairman, I just wanted to say on the procurement issue raised by Mr. Young, I think there was an extensive article over the weekend. I don't know if you all saw it, from Dr. Margaret Rose. Yes, that's right. And she actually dealt with that issue of directors' duties in relation to the procurement regulations. All I will say as a general thing, the more things that a company has to do and to carry out administratively and properly, the more onus, the greater onus on a director to fulfill their duty under Section 99. They have to be more careful. It's just an added layer of responsibility, and therefore they just have to be more careful and diligent to fulfill those duties. And that's what I'll see with that. The second thing about will the judgment discourage directors? I don't think so. If anything, it may have the effect of bringing out more sophisticated directors, if you understand, because the judgment will show them you know, where they can go astray and where they can fall down. And so
Mm-hmm.
they may wish to educate themselves, or the company may wish to educate them in terms of what their duties are.
Well,
So,
that's
you know,
why.
it could be like that. Or you know what? Bring in a lawyer and let the lawyer teach them. I don't know. I'm plugging for work for lawyers there.
CCGI is well equipped to do that. But I want to change the conversation a little bit from the state-owned enterprises, because this speaks to directors' responsibility for any enterprise under the Companies Act. And I don't know. I serve on a few boards well. And I have witnessed directors coming into meetings unprepared. They haven't read the board papers. They don't add to the conversations. So for me, directors in private enterprises also have to be mindful that they have a duty to be diligent, to be questioning. In other words, if you don't understand, you need to question, and you need to ensure that you've been properly advised in areas where you may not have the requisite expertise. What are your thoughts on that?
Well, if I could just go answer that, Nigel. That's what I said at the beginning. I said,
Yeah.
even though this was a state enterprise case, the principles apply equally across the board to private sector companies. And you know, for example, and I'm just plucking this example, for banks, for instance, insurance companies, where there's so much liability in terms of filings and the regulations and what they have to do. And then the fines are huge for these entities, 5 million, 6 million, and whatever else. What happens if something is done, which and the regulator gets involved, and there is a fine of 6 million on these entities? I mean, what is the role of directors in that? I mean, did they know what was going on? You know, why did it happen? I mean, it's onerous. And sometimes it could be more onerous in terms of private entities, especially those regulated by a third party.
Yeah.
No, good point. Terry?
You know, I was just going to support the point that Camille Pacey made in the chat. The idea of the minister being able to give policy direction and directors still having to carry out their fiduciary duties. Absolutely. The problem is that, and I made a suggestion about the regime, creating a special regime. But in addition to that, what we also need is that we need to have a change in the political culture. So Colin is thinking that more directors are going to come on and so on. They will come on because they are party people. They belong to the party, and they're going to be loyal to the party. We have had a situation here where one attorney general called a meeting of all state enterprise directors and told them that they're supposed to be loyal to the government, not to be loyal to their companies, right? And this was stated. So people are going to come because but what happens here as a matter of practice is what Martin Daly called many years ago interfering intravenously inside of these enterprises. So the politicians, the ministers, are not content to create policy and allow the enterprises to move forward with the projects and so on to drive that policy. They're not content with doing that. What they do is that they interfere inside of the enterprise. They call up the CEO and they say, I want you to employ X or Y. That's an operational matter. That's what happens every day in our state enterprises. So the political culture has to change. And the politicians, the ministers have to learn that they need to step back into the realm of policy, clarify what this entity is supposed to do, put it into the hands of competent, independent directors who know about governance and know about the particular thing. So I put people on Caribbean Airlines who know about airlines and so on. And I put people who know about these things and then allow them to carry on and to deliver the policy on behalf of the government. That's what we need to have. But we will live in hope.
Kamla, you wanted to say something?
Please, Mr. Moderator, our chat is overflowing, and so I want to ask persons, since this is such an important issue, if we can extend our time with this discussion, please, because we are actually just 4 minutes away from our planned end time. I'd like to ask everyone if they're willing And if our panelists are available, please, 15 minutes, half hour, if you're okay with that. But this is really critical.
I can tell you I have a hard stop in 15 minutes. So
then I would be able to continue.
Yeah, you can take it over from me. Don't worry.
Right.
So,
okay. So thank you, everyone. But those who may need to leave, the survey is already in the chat. Please make sure and click on it and give us your feedback. But let's continue this very critical discussion.
Sarah Yualande, you want to add anything?
Yes, I had one.
Oh,
what?
Sorry, go ahead. But before you go, Camille, also somebody asked if a volunteer board has the same kind of fiduciary responsibilities. Definitely.
Exactly.
The fact that you don't get paid does not absolve you from being careful and being diligent. But go ahead, Yualande.
Yualande,
whatsoever.
on your video.
I'm so sorry, Kamala. I was going to explain that it's raining very heavily where I am right now, and it's interfering with my Wi-Fi and bandwidth.
Okay, no worries.
My
Go ahead.
apology. Right.
Go ahead.
I can only reiterate the point that your fiduciary duties remain as they are, irrespective of which board you serve. What we do in Jamaica is that these state enterprises are aware of the minister's agenda and policies for the period, and there is an attempt to follow those policies and to further them, but not when it clashes with your fiduciary duties. That has to take precedent. And the solution, in my opinion, lies with not just being proactive and getting legal advice, not being reactive with it, but also to ensure that corporate governance principles become part of the culture, the very fabric of the enterprise. And in that way, any new directors coming in will understand through knowledge and education and programs that these fiduciary duties are essential and they are priority. I think that will move, and ensure that things move in the direction that we would like.
Yeah.
Yes. So in relation to your initial question about, yes, the judgment talks about state-owned enterprises, but it also related to many things to private companies as well, in relation to the duties of directors. What I would like to add is that, yes, directors of private companies also have to ensure that they act with a duty of care. And also, as you mentioned, there may be persons who may not read the minutes beforehand or prepare a reading board book beforehand. That is critical, because if you're going to make a decision which is going to impact the company and employees, etc., then you need to understand what you're deciding on. One thing that I would like to add on that is that expertise, because an easy example, let's say you're the company is an insurance company, for example, and right now there's a lot of cybersecurity issues. There may currently be no one on your board who is an expert in cybersecurity. You may have a person who may understand networking or some aspects of a computer, but they do not understand cybersecurity. In that instance, then I think it's very important to seek external counsel, seek an opinion from someone in the field, and have recommendations made. So I just wanted to state that as well, because
good point.
Asking for, seeking external advice or an opinion rather, is actually part of your duty as a director. Yes.
Thank you. Any more questions? Let's see in the chat.
There's several, but Chantal Paul also has her hand up, so maybe we could invite her to answer.
Yeah.
Very brief, please, Chantal.
Good afternoon, everyone. I just had a question. I know we would have spoken about directors losing their opinions and that being recorded, but my question is, and we could even use the UOPR guidelines as an example. Is it enough to decide, or in certain circumstances, is it that certain things must be reported? Because, for example, under the new procurement legislation, there's the real threat of fines and even custodial sentences. So if it is, for example, we have a company being chosen that is not even on the procurement depository, or a competitive process was used and certain things are overpriced. Is the sentence enough, or is it that a director has a duty to report certain things in addition to noting their dissenting
Thank you.
point? That's my question.
Lovely question.
Very good question. Thank you. Legal minds.
Well, you know, one of the things I would say, and partly to answer Chantal's point about the procurement thing, and also Margaret Rose's point about this procurement thing, is that the procurement legislation governs state enterprises, right? Governs state entities. Now, the reason why these state enterprises were created by the government was to expedite things. They don't want things to get bogged down within the mainstream public service. So you create these enterprises in order to accelerate the thing, to get around the central tenders board, to do procurement faster and so on than what happened in the case of if you left it within the mainstream public service. So now that the procurement legislation has now come, and you are saying that directors and boards of these enterprises now have to follow that, and they are going to be liable and so on and so forth, it means that is it going to be the case that these state enterprises will then slow down, right? Because they have to follow these bureaucratic processes and so on, which don't apply to private companies, right? Which is why they were created in the first place. And so therefore the government has to now rethink this. And this is one of the reasons why, in terms of our procurement legislation, there was how many years it took? It took 10 years for it to be actually implemented, because I think the government was recognizing that it was have all of these implications and ramifications for, you know, for state bodies. The other point that I would want to make, which is related to that, is that in the private sector, we have boards. We have people on private sector boards who are very knowledgeable about corporate governance, whether banks or insurance companies and so on, very knowledgeable. But you make mistakes. You carry out due diligence. You do all the things that you're supposed to do, and you make mistakes. You get things wrong. You lose money. These things happen for real in the private sector. And you do that and you press on, okay? In the public sector, with a state-owned enterprise, you lose money, the government changes, and the new board that comes in now says your due diligence wasn't up to mark, you lost money, and we're taking you to court. I'm saying that what that does is that it poses an additional risk for people who decide that they want to become directors of state-owned enterprises, particularly in situations where governments have changed. Because as I pointed out, all these instances that we have had in the last 15 years have come about when things have changed. ETEC, UTT, EMBD, all of them have come about, and SportTT have come about as governments have changed, and the incoming board has now gone back and said, hey, you made a mistake there, and we're taking you to court, and you're going to be personally liable.
Absolutely right, Terrence.
Colin.
In relation to what Chantal asked too, if I could just say that there is a duty on a director of a company, if he's aware of any illegal conduct being carried on by the company, that he has a duty to object, and he has a duty to bring it to the attention of the board. And if the company does not course correct in terms of that illegal act, then he should resign. And that's what the cases say, that he should resign. I'm not sure, and you know, I do apologize for this, but I'm not very current on the procurement regulation, so I don't know if there's a duty in there for a director to speak out and report the illegality, if there is some illegality. So I'm not sure about that, but I know that a director internally has a duty to bring these matters to the board and to course correct.
So if we go to the chat, Nigel, there were quite a few comments from persons. Particularly we have from Mr. Robert Riley. So I am wondering if we could ask him to unmute and share his thoughts and concerns with respect to the conversation. Yeah, so let's add him.
Yeah, I'd make 3 quick comments. Thought. It would appear to me that, and I've seen that recently, there's in the state sector, in the state enterprises, there's been this well, of course, direction by government and almost blind following of the request, as we could see in this case. I want to also say, probably most importantly, there's also a kind of contagion of that culture seeping into private enterprises and also public listed companies. And the instances where a public a listed company is owned by a number of these state enterprises, and they could actually add up to the majority. And there's seeping into that scheme an expectation that those directors would then follow the dictates of this majority. And it's a very insidious kind of infiltration, in the sense that the threat of follow it or go. I have been thinking a lot about this. And I'd say there are 3 or 4 approaches that I think, you know, sometimes in public companies, they do it well. Not always, I will tell you. So Terry, I'm learning that it's not always that these public enterprises are as good as we think they should be. I think, first of all, directors have to make sure that the internal organization of the company is done properly. And by that, I mean, there's a clear understanding of the role, and not just understanding in some policy, but understanding in the way it's practiced. The distinctions between the role of management and what they're expected to do, the role of the board, what is expected to do, and particularly because of this contagion, the role of the chairman. Because in state enterprises, the role of the chairman is becoming almost the CEO. I can give you instances, I wouldn't name names here, of chairmen who are not even referring to their boards before they issue directives to public listed companies to take actions. So understanding everything from the delegation of authority and paying attention to it. And interestingly, I've been searching a particular entity recently, and the DOA is so unclear that the role of who does what is palpably unclear. So the internal organization of the company is a really important approach to being able to discharge your duties in a manner that would meet the standard of the law. Secondly, this issue of distinguishing policy, which is very important because there can be conflicts there, from the operationalizing of policy. And that often is a documentation or an approach which goes way down into the organization. And then third is what I often call the decision support package. When a decision comes, of course you have to make it, but it has to be informed and attested by expertise. And I will tell directors this, it's very dangerous if you're trying to be independent to rely on your expertise alone. First of all, it may have been expertise that's way old. You may have experience, but you need to hear the current thinking and the current state of the thinking on those areas. And you can rely on expertise, and it often is both a sword and a shield in the way it operates in terms of your own particular liability and the quality of the decisions you arrive at. And then Terry, of course, I want to say I agree with Terry and the need for change here, and I hope the courts will continue striking at the heart of this to force the culture of accountability that directors hold. Because I think that's also the big missing that we haven't talked about. There are a lot of serious directors, serious names in this country that don't take seriously the accountability that they have. And what I mean by that is, and I think Colin, you referred to it recently, this issue of when dissent is not sufficient, when it's illegal or it's so damaging to the company that your duty to the company is to step down and not be part of it. And I've heard some directors recently say, well, I couldn't step down because what would happen to the company? And also the duty in the face or to say no to a decision as a board and stand by the risk that, of course, the shareholder can say, sorry, I need to move you. And there's a process for that as well. And I think until directors themselves understand the first three poles, but more importantly, are willing to stand on the resign, or step down, or take the risk of being fired, and of course the public consequence in a small country, I think this contagion will continue. Because there are people out there now in the public domain that believe these directors, particularly in state enterprises, and I will tell you, even in my role as a chairman, people are starting to say, well, you have the decision to make. And it is so painful to explain to people what the scheme of accountability is and how it's charged. And it's informed by this insidious contagion that's coming from the way state enterprises and their governance is being mishandled.
So one of the questions here was, I also think who the board reports to also arises, and Terry made the point with the legislation from New Zealand and Norway, the whole question of the line minister and the corporation soul. And in the case of NFM, I remember having to have conversations with both. But again, one had to be very clear and very deliberate as to the purpose of the company and what it was set up to achieve, and make sure that one tried to educate, and hopefully the person on the other hand would be receptive to your guidance and your counsel. But one cannot shoot the responsibility. So I have to leave. I have a doctor's appointment. Kamala, I'm going to hand it over to you. Before I go, I'd like to thank Colin, Terry, Yualande, and Chad for a very engaging conversation and a very engaging discussion. And I look forward to more of the same as you all. So take good care. Thank you.
Thank you very much, Nigel. Appreciate your expertise with us as always. I hope all will go well with your doctor's appointment.
Yeah. All right. Take care. Bye-bye.
Yes.
Bye.
Now there's a
Dr.
question in
Farrell, could I-
that, Dr. Farrell, I think might be your call to answer. That came directly to me, and this was someone wanted to know if members of a national steering committee have the same fiduciary duty.
National steering, I don't know what that means. I'm not sure what that means.
So I would imagine similar to the steering committee that you were part of that reviewed the role of state enterprises and that kind of thing.
No, not like a committee or something like that. No. Sometimes the government sets up things like for example, with the World Cup and so on, they set up committees to run the thing, but they were not companies. They were not set up as companies. So in those circumstances, no, you don't have the same kinds of responsibilities and so on. I wanted to kind of link one of the points that Robert made and the point that Nigel made about, and this goes to the question of minority shareholding. So the government may be wholly owned, majority owned, or minority owned. One of the things that the Norwegian and New Zealand legislation is very, very clear about is that when it comes, if the state is a majority or minority shareholder, they step back completely and they deal with things only in the context of the general meeting. There is no question about any directive, absolutely no question about that. They step back. In our context, what we find here is that even when the government is a minority or majority shareholder in something, or indirectly through something like the NIB and so on, that it seeks to influence the enterprise by doing all kinds of things, by looking to appoint directors and to have these directors, as Robert saying, report to them and so on. I mean, I don't know that people appreciate the kinds of things that goes on in these enterprises, with these governments, with these politicians. But it's insidious and it's very difficult for directors in those circumstances. So as Robert was saying, if you take on that responsibility, you have to have, you're either going to be a party loyalist and you will take instructions and you will do what they say, or if you are independent, you have to be prepared to ignore them. So if they tell you something, I am not doing that. I ignore you. You want me to hire somebody? I am not doing that. These are our procedures. I'm not hiring that. And if they want to do something illegal, you tell them I report it to the police. And if at the end of the day, you come to a situation where your views or the views of your board are totally divergent from that of the government and what it wants to do, you have to be prepared to resign and to step away and to make that public. And in our context, it is very often very difficult, I think, for directors to take that step. But it is important.
I understand. Thank you so much, Dr. Farrell. And I saw that Richard put in the chat earlier that possibly CCGI may want to lead the charge to lobby for government to adopt the recommendations. I just want to point, so those recommendations were made in 2016, and I don't know anyone who is more qualified than Dr. Farrell to have been lobbying for these kinds of changes all the while. So it tells you that there will be significant reluctance on the part of any government to give up the power that they currently would have in the construct that exists. So there is a question in the chat from Chantal that I think is really critical in today's context, especially as Dr. Farrell has pointed out that who really should be able to advise a board. So Chantal's question is, who does the board really report to? Is it corporation sole or the minister or even the president? So, and also I want to ask this question because generally the majority of state appointed directors will believe that their line minister would be the one who is authorized to instruct them. Although, as Dr. Farrell has clearly explained, by the incorporation, it is corporation sole that instructs you and not your line minister. But given that there's a general consideration that this is the practice, will it be a sufficient argument? I can't use the word defense in this context, but it's a sufficient argument to say, well, it is the norm, it is the precedent that is the line minister who would normally give instructions to the company, as opposed to
that is the norm. That is the practice. The question is that the law? And so Colin mentioned Gregory Smith's decision in Orokune. There's also a decision by Gregory Smith and Archie, where they both appeal court judges on TSTT on the question of the Integrity in Public Life Act, where they were deciding whether or not the directors of TSTT were to be subject to the Integrity in Public Life Act. And what they said is that, listen, we are taking a de jure approach to this. What is the structure? And the structure is that the TSTT reports to this NEL thing and it will go to corporation sole, and we deal with that. And in that context, these directors are not subject to the Integrity in Public Life Act. The de facto relationship, of course, is very different, right? So de facto, what happens is that the government comes into power, and then what happens is that the enterprises then get divvied out among the different among ministries. And that minister becomes the line minister for that particular enterprise. We documented situations in our committee report where that changed. One entity would move from one ministry to another ministry, which speaks to the question of the clarity or the lack of clarity of what the corporate intent of this enterprise is. What is it supposed to be doing? What is its purpose? What is the policy that is driving it? So in that situation, if a line minister is giving instructions or giving directives, people accept them as that's how it is because they're operating in that paradigm. But what Ricky Rahim's judgment has done is that it has now shaken that. And people have to now ask the question, well, should we take a direction from a directive from whom? The Margaret Rose's article is a very interesting article because she talks about the dogmatic principle and so on. And her argument is that what should happen is that really what's called the dogmatic principle, that the Minister of Finance, what he can do in a general meeting, he can do outside of a general meeting. There's only one shareholder. And so therefore that shareholder, then this is a question of what's called attribution. You can then attribute to the shareholder the company. So the shareholder says do this, then you can say the company says to do this, and the directors then say, okay, we can go ahead and do it. The problem with that resolution of the situation is that or you have 40-something state enterprises. And if you have decisions to be made, they can't all be going to the Minister of Finance to make them. It is just simply impractical. So I come back to the point, New Zealand model, Norwegian model, State Enterprise Act, line minister is also a shareholder in the entity. So it clarifies that issue. The line minister is responsible and he can give you his policy in terms of what he wants you to do. And by the way, in both cases, New Zealand and in Norway, you report to the parliament. The minister reports to the parliament every year. He reports to the parliament on these enterprises and what they're doing.
Right. And I saw that, in fact, Richard did put in the chat that it is supposed to be the practice that the state-owned enterprises submit an annual administrative report, which goes to the line minister and then is supposed to be tabled in parliament. And the question is, how many of them actually do that?
And we documented that in our report, and delinquency is rife. They don't do annual reports. They don't file annual reports. They don't submit reports to the investment division of the Ministry of Finance. All of these things that are in the State Enterprise Performance Manual, they just don't do it. A place like UDCOT, controlling millions of dollars, did not have annual reports for years.
Right. Now, so let's also put one other thing on the table, and I'm just going to rest it on the table and leave it there, right? We have been talking about the fact that directors take instructions and think it's okay if it's been approved by the line ministry. But let us understand that there are directors too who go in to serve in positions with self-interest.
Yes.
And in the majority of instances, it is because they are unaware that there is a duty, which when they put their own interest first to benefit from their position, that they are in fact breaching those duties and they can be held liable. So again, the point was made, training is so important. So we need to ensure that directors understand this is not something on the basis of, well, I've always been in a position and I know what to do. And there's a question in the chat from Dorelan. She said, recalling that senior counsel, so Colin, this is for you, recalling that Section 99 applies to companies, whether state enterprises or not, then for non-state enterprises, the shareholders would hold directors accountable.
Well, okay. I don't really understand the question, but whether the shareholders would hold the directors accountable, I assume so. It's really, but you see, the duty under Section 99 is really owed to the company, and it's the company who can enforce the duty, not really shareholders. I actually, my mind was running as I was preparing for this, that and this is a unique talent for lawyers. They're always looking for novel ways to sue, and so I was actually wondering if and it's just I'm just at a state of wondering whether an oppression action could be brought against directors in relation to breach of fiduciary duty, assuming, for instance, that the controllers of the company don't want to bring that action against a director. How would you do it? You don't, and for example, I'm actually thinking about publicly listed companies where you might have a majority shareholder and then a set of other minority shareholders. Something is being done wrong to the company that the minority is seeing, and they're seeing breach of fiduciary duties, or they think they are, and they need a remedy. And I was actually wondering, well, we kept the old derivative action from the Foss and Harbottle type actions under our latest Companies Act. So we have that, and we have the oppression remedies as well. So even I think we could get to the stage in the future of some brave lawyer going before the court and arguing, and Dr. Farrell, this could be landmark, and arguing, in relation to a publicly listed company, bringing an action for breach of fiduciary duties and stuff against directors. So, that's how I would try to answer that question, because I don't think it's really a shareholder thing. I think it's a company right to bring the action against the director.
Yes, I
I
understand.
agree completely with Colin on that. Derivative actions taken by the companies is intended to benefit the company. When the company sees that its directors are not doing what they're supposed to do for the best interest of the entity, it is really up to the affected parties to bring an action against the particular directors. Yes, I agree.
Thank you. So it's now 1:27 p.m. here. I just want to be able to read this final comment from Robert in the chat, and then I'm going to come to our panelists for their closing thoughts. And so what Robert put is, I have observed the practice of this change, referring to the comments from the panelists. He said, wise chairs and directors often engage in conversations and discussions with the line minister and corporation sole, and always keep both parties informed. Often today, it's even more complicated than that. I agree with Terry, it's all painfully inefficient.
Yeah.
Oh, thank you, Roxanne. I'm seeing from the chat too that you're saying that it's very excellent and relevant panelist perspective. So we appreciate you having joined us today. But let's do some quick wrap-ups now. Dr. Farrell, did you want to get started?
Well, just to say, I mean, that this is a situation where I think that people who are going to be appointed on boards need to become more aware of the risks that they run. And these risks are real. And I think the good thing about this judgment is that it should wake directors up to what can happen. This was just a slap on the wrist. It's $40,000. So in the context of things, it wasn't a big deal, but it could be significant. And they have to understand and appreciate that when you get a call and say, I want you to come on this board, you have to understand what it is you are getting yourself into. You are subject to the Integrity in Public Life Act, with all that entails. You are now a politically exposed person. I mean, we had a curious situation the other day where some minister, I saw in the papers, is complaining about the fact that the bank is asking him all kinds of questions about where his salary is coming from. And the reason for that is very simple. He is now a politically exposed person. And once you become a politically exposed person, the bank has you under additional scrutiny. Every transaction that you do as a politically exposed person comes under scrutiny in the bank and your insurance company. But people don't understand that. They don't. And then you have all of these risks now that you have with this change of government, and you have your new board suing the old board. And one of the points that Ronnie DeSessa always makes in these conversations is that when you leave the board, you leave with nothing. You leave with no document, you leave with nothing. And so therefore, when the litigation comes at you, you are going to be struggling to find a way to defend yourself, to find the documents and so on that will support your case, that you said no, or you dissented, or that you and so on. You're going to be struggling. So all I'm just saying is that guys need to be aware. And on the policy side, we need to have a completely different regime for state-owned enterprises because they are different. That's my point.
Thank you very much, Dr. Farrell. I really appreciate that. Yes, Colin, can we come to you now for your closing thoughts?
Yeah, I'm obviously in terms of incorporating state enterprises under the Companies Act. I don't think that's the best vehicle for executing government policy. I think there needs to be a change. I do think, and I don't know the extent of the change, but I do think directors of state enterprises need protection if they are to execute government policy. So we may think of two things. We may think of Dr. Farrell's recommendation about the New Zealand Norwegian regime, or alternatively, we have under Section 99 and following, we have a whole carve out, and maybe establish lesser duties for directors of state enterprises, and also to have them statutorily protected in the event that there are directives from government or a line ministry or something to that effect. But certainly as it stands now, there's too much tension between what is in the best interest of a company and what government policy is. There's too much tension, and something has to give. I mean, we can't go litigating all the time on issues like this. So something has to give, and there needs to be a change.
Thank you, Colin. I'm going to go to Chad next, but Yualande, I want you to also think about a third alternative, which is the Jamaican approach with the PBME and what that means in terms of changing the governance landscape. Okay, so Chad, let's come to you and get your closing thoughts.
Thank you, Kamala. In essence, my view is that presently there is a conflict between persons who serves on the board of state-owned enterprises and what the line minister and minister of finance may require or want from them. But at the present moment, given what we currently have, I think it is important to emphasize the importance of training, and so that you're able to understand what your duty is. That is significant. Training is significant. That is one big takeaway to leave everyone with that. And also to be brave in the sense that, one, if it is that you do not agree with a decision being made or a decision someone wants you to make, you should dissent on it. You should make your reasoning clear and submit it. And to add to that as well, which was also stated earlier today, is in regards to being brave, is sometimes you may need to resign. You should not feel compelled to do something that you do not agree with, or to even do an illegal act, which you may know or you may think or have any concern that may be illegal. Because at the end of the day, as a director, you may be held personally liable. And that is my takeaway for everyone today.
Thank you so much, Chad. Yualande, as I come to you, I just want to highlight and express congratulations to our director out of Jamaica, Camille Facey. We learned today that Camille has won a national award in Jamaica. Camille is the chair of the Corporate Governance Committee under the Private Sector Organization of Jamaica. And Jamaica, I have been, saying to everyone, has been so far ahead of the region in terms of the evolution of governance practices. And I totally so much like this Public Bodies and Accountability Act, the Public Management Bodies and Accountability Act. Like in the law so much, I should learn the name to be able to say it straight off the bat, right? But that there's a whole system that Jamaica has created and made into law that I think is an option for us in the region as well. So Yualande?
Right. Thank you very much, Kamala. I had mentioned in my opening statement that the Public Bodies Management and Accountability Act, as well as the corporate governance framework of public bodies, have changed the way we approach governance in Jamaica. For starters, it has codified the fiduciary duties that are owed by directors of state-owned enterprises. So there's no question as to whether they're bound by it. If the Companies Act wasn't clear enough, it makes it very clear. It introduced criminal and civil penalties for directors as well, something that, would be in question before. It also reinforced the central issue that we're having here as to whether these boards are independent. I know there is still a tension between, ministerial agency, are we to further that, or we're to stand on the duties owed to the entity itself. But these pieces of regulations, I would call them, I wouldn't call them acts. The PMBA is an act, but the framework is more of a codified guideline of sorts. It stands on that and reinforces the independence of directors. It establishes the financial accountability mechanisms that are in place, because so many of these issues surround finances, contracts, and all that. So it does in fact give us a little bit more than we see in the region, and I'm hoping that it will fan out eventually and become a lot more codified so that these discussions can be a little clearer, have less gray areas than what we are seeing here.